So good morning, everyone. Hope everyone survived without broken pipes and cars that were frozen and everything else. It looks like it's going to be a balmy 80 degrees today in here. I think I'd like to start if the work session first with a pledge and ask our clerk if she would lead us. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I think we neglected to do that last time, and that was the one mistake I made all year. I am opening the work session on House Bill 301 that I introduced last week. For those that are new to work sessions, you can think of it almost as an executive session, but in a much less formal way. I'd like to try it so that we don't have to do things through the chair. We can toss out ideas as we go. I would only ask that if you have something to say, that you still have to use your microphone, and that will indicate who to everyone else who wants to speak. But as far as the content, it's anything to do, anything that's written on both sides. Well, on mine, it's both sides of this sheet of paper, or any other idea on conflicts of interest and ethics in general. With everyone, without exception, without objection, I'd like to let our very fine ethics guru, Rich Lambert, who's in the room, also be able to participate and answer any of our questions that we have as they come along. I wanted to make sure we understood that this bill is now in the hands of the committee. So all of the names that are on there don't matter. It is our committee bill at this point. So don't think don't think that there's any concern with saying anything you want to. I have very thick skin, even though my name is the first one on there. It doesn't matter. It is all of our bill rather than just mine. Okay. That being said, I would like to just start out and maybe start the conversation rolling by saying we have to decide somewhere, and I think right off the bat, what's the purpose of having this this section of our ethics booklet? Is it to determine or to provide the ethics committee a sheet to determine guilt or innocence? Or is it, as I think, something that provides guidelines, I guess, or suggestions or advice to our fellow legislators to decide how they should be acting, or just to, I don't know if brotherly advice is the right thing, but just some way, some offer of or indication of how you should have, what you should have as a guideline while you're determining whether you have a problem or not with a conflict. So that's what I think. If anybody wants to come up with a better solution or a better idea of what that booklet is, the reason I bring it up is if there is any concerns that I receive back or feedback from any of the people that have read it, it's that phrase in there that talks about people who are close to you. And and funnily enough, and I mentioned this to someone over the weekend, funnily enough, the people that have the most problem with that are people that come from the legal background. So the lawyers don't like that phrase. And I maintain it's because they are hoping to have, they're used to working with things that give them a sense of guilt or innocence from how the wording is done. And I'm not looking at it from that standpoint. So I guess rather than just keep wandering around here, I'm happy to entertain anybody else's thoughts about the purpose of this and where we go from here. Allison.
Hi. So I also didn't like the someone the legislator cares about. I thought it kind of. I thought that it really fell apart if like someone were to like I don't know like need to pay back a debt or something like that, and it was a conflict of interest, which like I hope no one's doing, but like that would also be a conflict of interest. So I just looked up like Massachusetts conflict of interest laws. And I got that language drafted as an amendment. If we wanted to look at it, if not, I'm fine with that. Yeah.
That reminds me, did anybody receive from Jennifer the, I don't think she's done it yet. I had asked for, I forget, I think it was Representative Payer that asked if we had examples from other states. What's that? We did receive that?
Yeah, we have all 50 states. It's categorized on all
Okay.
the things in 2 separate emails.
That might have even come from me now that I think of it. I'm not sure. But there were a number of them that we, no, didn't see it. Okay.
I feel like I saw it, but I didn't print it out, and I don't know where it came from.
This is the danger. All right.
February 1st.
Okay. So that's just last week, right?
Yep.
And that had every state listed, right? Because I also have with me from our work session over the summer, when we interim studied the bill, I have a sheet that we handed out then, and that just has some language from from select states, Oklahoma being one of them, Rhode Island, Virginia, and those are the ones that spoke to us as we were looking through that entire list that we're talking about. You still need it, all right? Okay, but you did receive the one from Jennifer. Okay, why don't you give me the email addresses that you want that sent to, and I'll try to do it while we're talking here, and then you'll have it. Everybody else is okay with that? Everybody else has it already? Okay. So what was it specifically, Representative Allison Nutting Wong? What is it that you felt that the phrase didn't cover all instances?
Yeah.
Okay. So here's another part of that, and maybe we jumped ahead a little bit. Another part of it is first determining from this committee how far from the legislator do we need to go? Is it some states you'll see only go as far as the legislator? That's where the conflict begins and ends. Some others look at the legislator and the spouse. Some others look at the legislator, spouse, and anyone that lives in your household or is an immediate family member, and so on. I think that phrase that we used in here encompasses all of those people and then goes another step. But maybe you want to add it even further and say, someone that has debts, whatever the phrase. Yeah, help yourself. Yep.
So I was specifically asked by my employer to recuse myself from any bill that would benefit them financially for any broadband type infrastructure bill, because that's who I work for. So could that be considered somebody, close to the legislator, the employer? I would think so.
That's actually already in here. And that's that part that you, Representative Tierney, were talking about, advocating for or acting as an advocate. In this case, you'd be acting as an advocate for, and there's another section as well.
Well, right in the new language, Part C says this persons may or may not include family members, friends, or business associates, and I would consider that a business associate.
Yep. By the way, we have, a lot of you haven't met Representative Constable. Representative Constable watched us on TV last week, or the week before. I don't remember. But now you can match the name to the face. So
On the big screen too.
you put us on the big screen? Not sure where to go with that.
Right.
So again, we, we have certain sections that we could either silo this and just say, okay, what do we think, first of all, how far from that legislator we should go? And then set that aside and go to the next section, or we can, shotgun this and go anywhere we want to go. What's the pleasure?
If you do it to where you put in specifics instead of someone the legislature cares about, if you actually put in relations and you go out to a certain point, but then a legislator cares more about two sections out or two relationships out than you named, does he have to report it? Is he guilty? Can he be thrown out? What gives? Because somebody the legislator cares about, that's up to the legislator. That's not up to somebody else to say. Maybe you don't like your grandchildren, for anybody who's got them. Or at least certain ones of your grandchildren.
I don't like your grandchildren.
And I've got 10 of them. But I mean, but if you've got great grandkids, maybe you care more about them than somebody closer up, but they're not listed. This lists them without listing them.
I agree, and our point was to try to get away from being a genealogy band, I don't want to have to list every possible relationship that could fall into this into the category that you would have to worry about, because certainly there may be somebody's stepfather's sister that that is in the same business that you're voting on an issue for that would help them. But I don't, that's why I was trying to get away, or we were trying to get away from the guilt or innocence part of it, because certainly there would be a loophole if you didn't name the specific relationship. That's what we're trying to get away from. What's that?
And that's why the lawyers like that idea.
Well, there you go. Yeah, well, I'm not going there. But I think that's part of it. And so, again, I think a fundamental question is trying to determine exactly what we're trying to accomplish with having this phraseology in an ethics book. I don't know that that's, well, maybe Mr. Lambert can tell us. Has that been discussed in an overall 30,000-foot view of what's the purpose of this ethics book? I know that they use the word guidelines in places, and I know, but it seems that when you sit and discuss a complaint, you are seeking to determine guilt or innocence at that point. And that's what makes it this conundrum.
More of a question though, but that it's still a guideline. Doesn't that then come to a vote? So it still comes down to the House deciding, right, on the ethics.
Well,
It's like
yeah,
they could
ethics
say,
comes up with a
they
recommendation, and
they
then it
come up
comes
with
to
a
the House.
recommendation, right? It's not guilt or it's like we believe this legislator should be censored, perhaps, or expelled for something, and then it comes to the House, right? And then we have to vote on it. So it's still, it's not, to me, it's not guilt. This is not strictly written as law, right? It's more, to your point, to me, it feels more like a guideline for legislators to, when should you recuse yourself? And it shouldn't just be, I agree that it shouldn't just be family members, right? Or business, so we should take that leap, but getting the wording right is a little tricky, I think is.
Thank you. Anyone else?
Yeah, I think the problem that I think with this is that when we're using household members, it's easy to prove who your household member is. It isn't difficult to prove who your friends are. We're having to write down our household members and what, conflicts we might have because of where they work. If we get to going further and further out, I mean, when we fill out our ethics sheet, instead of just including household members, do we have to write like our first 50 friends? Do we have, what I mean? Like it's sort of, I understand the purpose of it. It's like a best practices guideline more than anything. But like if we're getting, what we do here when we're writing a law is unfortunately legal. It becomes important that we know a distinction between whether somebody's breaking the law or not breaking law, because we've created the law by putting in special persons. So I think that's what worries me. Is there some way that you could just move it to a best practices thing, and maybe the rules regarding whether or not somebody gets brought up on ethics charges remains just household, as opposed to, well, I know this guy's friend does this thing, so I'm going to complain, sort of stuff. So that's my 2 cents.
Yep. Anyone else? I look at it as once you get to this point, and this probably tells you more about me than anything else, but I envision the poor guy, the poor representative that's sitting in the middle of a row, so having difficulty getting in and out, and listening to testimony, and all of a sudden a name or a face or someone he cares about, someone he knows, he is identifying with that testimony, and he's thinking to himself, gee, should I not, am I crossing a line here by voting on this issue? And he doesn't have his family attorney on speed dial, so he doesn't, so he can't find a quick answer. I think that's the purpose of the book, and I would like, we talked about it last year when we had the other bill, I would like to almost have a one little laminated sheet that that everyone is given that just says whatever we come up with out of here. If you have someone that you're close to, or someone, whatever we end up coming up with, and they can just look at it. And we had talked about a decision tree, just having, is this an issue that you are aware of someone, your business handling or whatever, and coming down just so that person sitting in that seat would have a better feel for what they should do, and know that at the very end, if you still decide to go ahead and vote on this, you are potentially opening yourself up to a complaint and or tarnishing your reputation and our reputation collectively. That's how my mind has worked as we were working through different work sessions and executive sessions on the prior bill, all of that. That's how I'm trying to reach a conclusion on this. I don't know if that helps or hurts. We also have an added advantage. Aside from having Mr. Lambert here, we also have another member of the Ethics Committee, and I don't know how, Janet, this interferes with your, where are your, where do you, yeah. I don't know if this interferes with your ability to do your job in the other committee or here or not.
Not at all. Actually, some of us were wishing that we had this workshop or whatever we're calling it this morning after the Ethics Committee meets next Monday, because Chairman of the Ethics Committee, former state rep and former Senator Ned Gordon, is drafting language to help us, and he is very skilled at what he does in a very brief and understanding way. But I think we're going in the right direction. Everyone's struggling with this at this point. This doesn't interfere with our work at all. I had mentioned to our chairman some weeks ago that the only thing I came up with was someone with whom the legislator is closely associated rather than someone you're close to. And Representative Nutting Wong has come up with a wonderful amendment that she's actually had drafted. Could we look at that, please?
Sure, absolutely.
Copies for everybody?
Wouldn't we have the same problem with someone that is closely associated? I would think that that's also is what you think is closely.
Are we closely associated
Right,
now?
right. Yeah, that's my initial reaction anyway.
Mr. Chair,
Yes.
Steve.
Hi.
Um,
Oh, sorry.
a lot of these terms that we're throwing around here are going to have to be extraordinarily defined in a very rigid way, because a lot of these terms are ambiguous. They're subject to mountain of interpretation, and I have concerns when we talk about cares or associates, or I'd need to know what that, I mean, okay, I went to college with people. Does that make them my associate? Does someone I went to high school with make them my associate? Is the ethics committee going to want my Facebook friends list? Because when you use a loose term like that, people define it in their own head, right? We look at that and go, okay, well, in my mind, it means this. Well, that's all well and good, but in Representative Payer's mind, that might mean something different. And of course, when you get in front of the ethics committee, they're not necessarily even going to agree with something that's not rigidly defined, because in their head, they have a definition as well. So I don't know that we can talk about generic terms like this, but if we're not going to include a definition of those terms with it and discuss a definition, then we're going to kind of be, I don't know if we're really solving anything as a collective.
So I think the fact that you came in a few minutes after the time we had talked, that was part of our original discussion of whether we should have defined terms, and the fact that some have not appreciated the term, those you care about and maybe now associate with, because you have to decide first, Representative Pearson, what your purpose with this booklet is. Is it to determine guilt or innocence, or is it, and that's where I think it sounds you're headed, so that the something is black and white or defined, to use your term, in order to make that clear determination, like we do in a court of any substance, or is instead the booklet there as a guideline to aid the representatives or the representatives and senators to determine for themselves, because ultimately ethics is what you think it is. In my opinion, ethics is what you do when no one else is looking. So for me, it is more a guideline than it is something that guilt or innocence is going to be determined on. If you think that this person, that your college friend is, to use the definitions that are in the bill now, if you think your college roommate is someone that you care about to the point that you would change how you're voting because of your knowledge of that person, then yes, that's who we're talking about. But if it's somebody that is, lives in your house that your son or daughter brought in, and you don't know them, then maybe not. That's where I'm going.
Well, I can appreciate that there's other folks on the committee that are thinking along the same lines that I am. Sorry about my tardiness, but your point for your personal definition of ethics,
Well,
I don't disagree with.
it's in here.
Except when you sit before the ethics committee, your personal opinion is now really not, it's part of the equation, but you are sitting in front of an ethics committee board who's deciding whether or not you violated the ethics standard. So it's all well and good that your personal opinion is framed in such a manner, but the ethics committee is going to make a decision on the complaint that's brought before them. And that goes outside the scope of what you think you did. And that in the guidebook that you're referring to, I presume will be part of that ethics hearing. So that's not just a guidebook for the individual legislator. That's a guidebook for the ethics committee as well.
Well, maybe you would like to comment on that. Oh, I'm sorry, I didn't see the hand.
I understand where you're coming from, but it's critical as legislators that we all understand if we step over a line, there are problems. And I have brought up before this committee before, and will again, the fact that when I sat on judiciary, we had a number of members who were landlords. And we also had a number of bills that were landlord-tenant bills. And it was very, very important that right up front these people say, I'm a landlord, and yet this is what I believe, and this is my experience, and so forth. If the person did not do that, which did happen, that causes a problem because a landlord clearly has different opinions from a renter. And this is why we have to have definitions. And this whole issue of conflict of interest, I have an article in front of me from the New York Times last week with the U.S. Supreme Court. One of the wives of the Chief Justice, actually, his wife, is being questioned because of a possible conflict of interest. And that substantiated my opinion in terms of the concept of conflict of interest. How did I word it? Let's see. The legislator or one who is closely associated with the legislator or the issues with which the legislator is dealing. And again, Representative Allison Netting Wong has carried a step further to clarify, and I think you might want to hear that.
Absolutely. I just want to make notice that the clerk did not mention a single person recused themselves from a vote we took last week involving landlords. And if you're going to tell me that 400 members of our House, not a single one of them owns rental property,
I think the
you're
number-
crazy.
I think the number is 40.
40 that own?
Yeah.
Okay. Not a single, the clerk did not mention a single recusal. So are we looking under this proposed idea in 301 here, are we looking at 40 ethics violations?
Mr. Chairman, may I say?
And-
Yes, sure.
I'd like to respond to that if I may, please. Remember, it's not just the single type of issue you're talking about. You have to associate a lot of the other parts of the guidelines. It's critical that we disclose. That's why we have our disclosure forms.
That's how
And
I came
these,
up with
that's how
40.
we,
Yeah.
yeah,
But,
that's
but
how
we do
know
that
have
now.
40.
You're asking to change this. We do that already. I filled it out 3 times in the 3 terms I've been here. So you're asking for a change. I don't think any of us are debating whether we should have ethics guidelines. Of course we should. We currently do. What we're talking about here is changing those guidelines from what we have to something different.
We're talking about clarification because there has been some concern among all members who have paid attention to this, and that's not to criticize anybody, but as all members who have looked into this are concerned about the definition of conflict of interest, and that's why this committee is struggling to more clearly define that. Thank you.
Let- I don't want to lose sight of the fact that what prompted this bill and most of the wording in this bill came from the chair of ethics last year, who, and if you read the first 4 Roman sections here, specifically called for a change to how that book is. So it's not that we're, you're absolutely right. We are talking about a change, but we're not dreaming it up out of thin air. We're taking it from the request of the chair of ethics, who feels that they need that. That's the point. But I agree. I mean, we are talking about a change. At some point, Representative McCarter had a question, but I don't know if we've already gone past that or not. Yep.
So I am thinking this out loud here. Forgive my ignorance. However, it's on us to recuse ourselves from something that would obviously financially benefit myself, my family members, whom people we care deeply about. Okay, what if my neighbor 2 doors down, his wife works at X company, and something that's coming up is going to impact her company? I don't know that's where she works. However, she's my next door neighbor 2 doors down. What if somebody else on the legislature wanted to initiate an ethics complaint against me because my neighbor 2 doors down works at X company that I don't know? Now it's on me to determine that course of action. I'm just trying to navigate this. That
What's the procedure?
what is the
that what-
procedure? Who lodges those complaints? Is it who defends it later?
So we have 2 people that can walk you through the system. Why don't you explain if someone wanted to file that complaint and thought that you had done something that you shouldn't have voted or should have disclosed that this neighbor was, how would it operate? Go ahead.
And Rich is here, he can correct me if I'm wrong on this one. It depends on how close you are to that neighbor. If that neighbor has considerable influence over your opinions and your actions, then it's best if you do disclose and recuse yourself if you feel that you cannot be objective when it comes to your decision making.
I respect that. I get that. However, let's say someone else doesn't understand that I'm able to make that barrier and I'm able to make that differentiation. Somebody else just knows that so-and-so lives 2 doors down from me and it probably did influence, they don't know that it didn't, but they can lodge that complaint against me or you anyhow. Where is the line that, who's off limits at that point? My former neighbor that moved to Florida and his brother owns a company in Nashua. I mean, like, where's the line drawn?
Wow.
You cannot, this is me speaking, not, any official ethics. I'm not a member of the ethics committee. No one can stop another person from filing a complaint against you, right? So it would be then the job of the ethics committee to ask you to appear before them, and they would ask you to explain what you've just gone through. This is my neighbor. I see them. Yeah, you can make up any story you want. I don't know the complete scenario, but then they would judge the veracity of what you're saying, and they would decide whether there was whether it was justifiable for them to file an ethics complaint against you or not. We were somewhat careful in here to say that, you know, this person, just because they live there, it doesn't necessarily mean that you wouldn't have voted that way anyway. And that, I don't know really how the ethics can judge that other than from what you say in your frame of mind, you know? Yes, I am aware that they're in that business, but here is how I have voted in the past in these types of issues or something like that. It will ultimately come down to you're defending yourself against this complaint. All I'm trying to say is this booklet needs to be your warning. I hate using that word, but your, yeah, you need to be aware that when you vote a certain way, if you choose to and not recuse yourself, then you are opening yourself up to that ability to have a complaint lodged against you, which you will have to answer to. Does that answer what? Okay. That's what I'm trying to get to, or that's the purpose of this meeting. Yep.
There-
Mr. Chair, I just see, there's a lot of room there, for lack of a better term, the activist types to lodge ethics complaints against people.
Absolutely.
I'm just, I agree with Representative Pearson that it needs to be dialed in and very finitely itemized for that purpose. Because once it's out there in the media, it isn't coming back. It's out there. And
Right, but it's within your power
Mhm.
to not have that be a weapon used against you. That's the point. And we don't have that weapon. According to the chair of ethics, he believes that there is a need for you to be able to defend yourself using recusal. Yeah.
So one of the things that, going back to my commerce experience, we disclose things all the time, but we rarely recuse ourselves from votes. I mean, we're a citizen legislature, so a lot of the people that were on commerce were business owners or landlords, or, you know, I served at, you know, going back, I live in a house now, but at the time I was living in a trailer park and we had trailer park bills, right? So what we would do is disclose that information and but upfront and to the public and to especially an executive committee, we would disclose that this is my conflict but that we will participate. And I think that should still be an option going forward. So I have a little issue with like where it says the legislator shall recuse himself. I think it should be may recuse or disclose, right? And I don't want to force us to. Commerce won't get done. Commerce Committee would not get done. Okay, because there would be, exactly. And
Right.
then what you would have to do is then take the people that have the expertise in those committees and take them off of the committee, and have them serve somewhere where they have no experience. And I don't think that's what we want to do. But what we do want to do is make sure that we as legislators, as a citizen volunteer legislator, that we're disclosing that I am a landlord, but I will be participating in this vote and have a clear conscience about that. Where you should recuse yourself is where the influence would change your vote, right? If you're going to vote one way and that's how you feel intellectually, that's how you're going. There's no conflict. You disclose an interest, but you don't have to recuse yourself because that's how you're voting. Where you need to recuse yourself, and this is a personal thing, is when that interest would change your vote from a yes to a no, from a no to a yes.
That's what it says.
That's the ethical violation.
And that's what it says.
And that's what it says, right? But well, up until 14C-A says the legislator shall recuse himself or herself from voting. Where, you know, probably should be more of a may recuse or disclose, something
Yeah,
like that.
I don't think I disagree with that.
You know what I mean?
There is also, and I don't think this has been brought up, but you reminded me. Because we are a citizen legislature, one of the things that we discussed heavily, maybe more heavily than anything we've talked about here now, was the fact that we didn't want to stifle specialized information that the legislator may have because of their life experience. So we specifically said under the exclusions or somewhere here that if you are in committee or even on the floor, if you wanted to discuss or testify or that would just be done with a disclosure as it is now. It was only the voting that we were suggesting would be the recusal part of it. So we didn't want to lose the institutional knowledge, I'll call it. I don't think that's a perfect term, but and we didn't want to, I don't know if this is the right term either, but disenfranchise that person's constituents that they represent. And they would be able to then testify with that disclosure and say, I am a landlord, I am a, policeman, I am a whatever you want to say. However, at that point, from that point on, we felt that the suggestion would be, not the shall, but the suggestion would be that you avoid the possibility of a complaint being filed by disclosing. And I think that's what this says. That's how I read it. Yep, sorry.
I just have one question or for some clarification at the beginning. It says real or perceived benefit. Perceived by whom? Perceived by the legislator himself or perceived by the public in general?
Hi, that's on my amendment.
Oh, no, it's also in, sorry,
is it?
it also is in, I'm also talking about what the law is, or the change to the law now.
You're
But,
welcome to
Okay.
speak.
I
to-
was
What
just
was your thought?
but
trying to
either of
keep it
those with perceived, I'm curious
the
of.
same, but I was also trying to avoid the definitions of like an interest, because it says so in the original bill we have, it says real or perceived financial interest or a non-financial personal interest. So in my amendment I had real or perceived benefit, financial or otherwise. And at the end of the day, it's about whoever complains about you, like however they feel about it. Like so it doesn't really matter what we think, but like you can get in an ethics complaint about anything. Whether or not it's found to be anything is another question.
I understand that, but that's why I'm saying that I myself can't recuse myself from something because I didn't understand that somebody else in the state of New Hampshire would think that I had a financial interest. If it says real or perceived by the legislator, then it's like, yeah, I think I might have a financial interest in this, so I shouldn't do that. That seems to make more sense than just any, but they all think we have a financial interest in this. So, anyhow, thanks.
Can I ask a
Yeah,
question?
sure.
Can someone tell me who is able to fill out a complaint? Who can lodge a complaint against a legislator?
Anybody,
Anyone.
Public?
anyone from the public, another legislator, anybody. As long as they're aware of what our guidelines are and what the real complaint should be. There are people who do file complaints that have nothing to do with the committee. So it behooves people to make themselves familiar with what constitutes an
Absolutely.
ethical violation. Could we please hear from Rich Lambert? I think he could
Sure.
give us,
If
thank
you-
you.
I
But-
did have a follow-up real quick.
Go ahead.
I don't know what the process is for complaints. Does the complaint go in front of the ethics committee?
Yes.
Yes,
And
And
an
Rich can tell
accelerating
you
number
step by
of them
step
as
what to
well.
do.
Okay.
We need to get it on. Yeah, I'm sorry. You can bring the microphone over there now if you'd like. No, you really can't.
I'd like to know.
Well, there are 4 steps in a complaint. One is when the committee receives a complaint, they need to examine it. And at that point, they can discharge it. And so the situation that Representative MacArthur was describing sounds like something that would be a candidate for discharge. If a neighbor 2 houses down filed a complaint against you for having, if someone files a complaint against you for the fact that you know someone 2 doors down from you, that would probably be discharged because it's pretty clear that that didn't violate anything either currently or in this bill, I would think. Can't speak for them. But the next step would be an initial review. And that's when the committee looks to see if something is, the complaint is within their jurisdiction and has merit. And at that point, the committee can dismiss the complaint. And unless the respondent waived confidentiality, all of that would be confidential. The next stage would be the preliminary investigation. That too would be confidential. And then the stage after that would be a formal hearing, which is open. It's like a trial. So that is the process. When the committee receives a complaint, it needs to be, the complaint needs to be sworn to before a JP or a notary, and it's confidentially filed, and then it's supplied to the committee members and to the respondent.
Can you speak to, thank you for that, those answers. Can you speak to any of the, I don't want to say issues or situations, but why at this time did the chairman indicate that we needed these changes? Without speaking for him, I understand, but.
Because there is no place in the booklet currently which requires recusal. As Chairman Gordon said, you won't find that word in the booklet. And there were several situations, several complaints which arose, and also a request for an advisory opinion describing situations or involving a situation or two where the legislator thought he only needed to disclose, but it was found that both of them had violated the section of the guidelines called prohibited activities, which is on page 4. And the first paragraph specifically says that disclosure does not save you, so to speak, from the activities which are listed as being prohibited. And so if you are being paid by an organization to advocate for them, that would violate several of these provisions under 3(2)(a) through G. And that was what was found to have been violated in 2 complaints, and also was talked about in the advisory opinion.
In the advisory opinion, it was, I'll summarize as go forth and sin no more kind of approach, where is it fair to say that had something like, this is a hard question for you to answer, but something like what was available under 301 here would have helped the committee do more than just say, go forth and sin no more? Is that?
Well, I would hope that it would have helped the member not to have done.
Not to have got to that point.
Yes, because the committee in the 2 opinions, 2 rulings, in the 2 cases, both were resolved by informal resolution, stated that the violations were probably inadvertent because the legislator felt that all he had to do was to disclose. And so, but the informal resolutions was agreed to, as they need to be, by the respondent, and both times the respondent agreed not to vote on, he agreed to recuse on anything that affected his organization.
Well, I'll keep jumping in here unless somebody else wants to jump in. At what point, what's the general feeling? What's your general feeling? Whether is this in order to prevent cases to come before the ethics committee and to advise, or is it to almost be a the litmus paper that someone is judged against? How
Both.
does both?
There are 5 parts to this. One is the guidelines. And sometimes I think the name can be confusing. They're not, it's called guidelines, but in many cases, it is, mandatory. It's not something you choose to follow because you'd like to. And violations of the guidelines can lead to reprimand, censure, or expulsion. In many states, they would call that the code of conduct. But here, for whatever reason, it was originally named ethics guidelines. But functionally, it is a code of conduct. Then there are 2 laws in the booklet. One establishes the committee's powers and duties, and that begins on page 25. And that is, there are violation of that. Not only is a violation of the ethics guidelines, but in some cases would be a misdemeanor. And then C, RSA 14C, which begins on 34, is the gift chapter. And violations of that also are a misdemeanor. Then the 4th part are the procedural rules of the committee, how they operate, particularly with complaints. And then 5 has a number of other miscellaneous provisions, including the policy on harassment, which you'll discuss later.
Yep.
And also 2 interpretive rulings, which were put in here to help clarify what to do in terms of acceptance of money for trips or how to comply with the disclosure provisions. And that one begins on page 64.
I do, you recall last year when we had the original bill, I don't remember the number of it. You do.
1368.
We had talked about a decision tree approach. Have you had any more thoughts about that, or has anyone played with that idea? Because that would seem to me, if it's possible, that would be more leaning towards the preventative side of this, so that we would have, you should probably let everyone know, we are on a dangerous path of complaints as well. The Ethics Committee has had a precipitous number of complaints in the last couple of years. So I would think the preventative side of things needs to certainly be part of our discussion here in this work session. So
That would be a great idea, but I haven't had the opportunity to work on it. Perhaps that's something the Ethics Committee can discuss next week also.
has the Ethics Committee talked at all about the possibility of having something to give to representatives other than I don't know how many
Yes.
pages we got here.
Representative
but,
Wall has been a champion of that.
68-page thing, if you could get it down to
Yes.
a couple page, so
Yeah.
that that was,
We have had that, and I also wanted to point out, to build upon this whole issue of disclosure, on page 65 at the bottom and page 66, the Declaration of Intent talks about financial interests, and that helps define this whole issue about if you have a neighbor who's in a business or owns a business and may have an influence over your vote. It would have to go, you'd have to look at more than just that aspect of it. It would have to be, and as it says here, if it affects you more, or your household member, or whatever, according to current definitions, you'd accrue more benefit than anyone else in the same position. So you have to balance all that in your decision making. Sometimes that is enough to help you decide. Sometimes it's not, and that's when people come to the Ethics Committee and ask for us to do our advisory opinions.
Mr. Chairman, one of the things that I find interesting here is, we talk in the bill before us in Part C, someone the it's a rental. Someone the legislator cares about, right?
yes.
But I find it very interesting on page 5 under permitted activities. The first thing listed is giving or receiving campaign contributions. It's amazing how fast a legislator starts to care about something when it comes to campaign contributions. And yet the first thing listed under permitted activities. So if we're talking about the public's perception, if that's what we're really worried about here is perception on the legislature, until that goes away, that's the paramount issue, is money in politics. So, and not only do we not even question if it's prohibited or not, we actually list it as permitted.
Do I hear an amendment? Is that what you're talking
I'm
about?
going to guarantee you right now that two things will happen. If I file an amendment to remove campaign contributions out of this body, I'm a dead man. And secondly, it will never fly and it will never pass. So that's a futile effort there. I mean, if you really wanted to go down that road, the executive council would disappear.
Well,
So
I'm trying to determine what you're saying.
what I'm
Are you-
saying is I'm trying to figure out what the intent here is, because if the intent is to fix a public perception problem, then that's the number one public perception problem politicians have. And we're not touching that. So
So maybe you're talking about a separate bill that you want to.
I'm saying that I'm trying to wrap my brain around when we're reading all these things in here that guide us, that tell us what to do, that give us direction.
Yeah.
Why don't we just leave it alone? I just don't. You're not selling me on the idea that we need to change this. That you know what I mean?
Well,
Because we're citing examples, we're showing procedure, we're talking about the book. Well, this is the current playbook. So
and we're concerned because there's a large number of, an accelerating number of complaints.
Sure.
Which tell us that there is something that we need to address.
yeah, but that may not be the.
And we're also being told by the chair of the committee that he needs, or they need, changes in order to handle the cases that they currently have.
I mean, if they're getting an increased amount of frivolous complaints, then that's just what they've
Nobody
got.
has said frivolous.
Have these gone through the process yet? All these complaints? I mean, we don't, without outcome, we don't know.
They
So,
are confidential unless the
yep.
unless the participants are open to disclosure. But it's
So-
also, it's not. I'm looking over past years. You know, if you look at and we had it at one point, the number of complaints. I think that was handed out actually at the freshman orientation. The number of complaints over the past 3 years or something like that. It is clearly what we have here isn't either educating the representatives to what they can or should do, or we're doing more things that are either publicly perceived to be a problem or not.
Or we figured out a way that, hey, we can kind of weaponize this. And I'm going to give you an example. You want to talk about issues in ethics? I was threatened with an ethics complaint if I advocated for something that has no financial interest on me in any way, shape, or form. Okay. So,
That's not covered in this.
except it is in the sense that if they're going to file the ethics complaint, it has to go through the process. Now, I would think it would get tossed in the initial process, but they'd have to talk to me first because I'm being threatened because I'm advocating for something that involves a board of directors I sit on, a board that owns no property, has no budget, collects no tax money. But because I sit on that board, they look at this and say, well, you're board member. It says board member, right? So this is the kind of crap that I think is going to expand with this, not be reduced.
Well,
So that's my concern with the language as it sits right now. And Representative Nutting Wong's got an amendment that we're apparently avoiding at all costs right now to talk about. But
why would you say that?
I don't know. We just keep going off on tangents, and
Yeah, we're
she's
not
asked to do that.
holding it
That was
by-
half a joke, but my concern is that we make this less clear with the proposed language changes instead of tightening it up. And That's how I see it right now, and I'm trying to wrap my brain around doing, that going in the other direction. But perhaps the explanation of her amendment would help in that process.
Thank you. All right. I'll take your advice. Representative Nutting Wong, would you like to discuss the amendment and what prompted it and what part of, I still see that special interest is in here, which was taken out of, that comes from the original language, is that right, in the booklet?
So my amendment says conflict of interest means the condition in which a legislator has a real or perceived benefit, financial or otherwise, for themselves or another individual that would not be properly available for otherwise similarly situated individuals. And for the most part, that's just language I stole from Massachusetts. Because I thought that it was way clearer than what we were trying to add. And I thought it was a good starting point for for this conversation, rather than arguing about someone the legislator cares about or what an interest is. There's other things we could be discussing. But I just liked it because I thought it was clear, that it made it, we didn't have all these weird definitions. And that was pretty much it.
Are you gonna take any questions, Mr. Chair, if we can ask in reference
they
to
should-
her amendment?
We're in a work session.
Okay.
You can ask anything you
Does
want.
this replace, just so I understand the nuts and bolts of this, does this replace all of one, so there's no A, B, and C anymore? This becomes Roman numeral 1 in its entirety?
Yep. So this replaces everything like in bold on the original bill.
So it doesn't deal with non-financial personal interests or,
No, that's part of the real or perceived benefit, financial or otherwise.
okay. Anything?
I kind of like it more simply because the part about it where it would available for otherwise similarly situated individuals. For example, if you have a friend that owns a car repair shop and you're voting on a bill that helps car repair shops, everyone that owns a car repair shop is helped out by that, not just your friend sort of thing. I think that this is a little bit clearer in the sense that you can have friends that benefit from votes because it's not about your friend, it's about the state in a whole. So
Yep.
I thank you for the amendment, and I don't want to be disrespectful, but I don't believe perceived benefit, perception is whatever your background is. It's not measurable. So I don't know that that would do anything to decrease the number. It might even increase the number of complaints if someone thinks there's an ethics violation. It might foster a complaint that wastes the committee's time. That's at least my initial thought on that. Maybe I'm reading it wrong.
So I thought I came up with that, but turns out I stole that from the bill itself. So that would be an issue we'd have no matter what. But yeah, it is kind of weird.
Can I say something else that I didn't talk about earlier? As a representative, I think we all come to the legislature with passions and initiatives, things that we want to fix for our constituents. And I have actually said in some of the thank you notes that I post to newspapers that when I vote on bills, I'm thinking about my constituents. They are part of my quote family now. And I don't want that to change because we are, as representatives, we are the relationships that we have. And that's why we're doing this job. So I worry about making it so vague and open to interpretation. It's just my thought.
Yep, go ahead.
I guess I'm getting a little bit lost here because in the beginning we were talking about what is our perspective. So bring me back into what the perspective is. Is this for me or is this for the perception outside onto me? Because the way I read this is I read this for me and I need to make a decision if I'm going to disclose or recuse myself. And I'm not worried about what someone's going to complain about me in this booklet. Or should our focus be we're getting a lot of outside complaints, maybe they're perceived, maybe they're not, whatever, but it's an outside influence onto the legislators that we're trying to deal with here. What do we, because I don't think you can split that hair. I think we have to make a decision. Are we going that way or this way and make that decision? Because I feel like we're going like this. Is this an outside perception or is this for me as a legislator?
If you're asking me, it is to advise you, the legislator, and to get back to that word guideline. I think that's why, or code of conduct, whichever you want to. I think this is to help you know how to act and give you the ability with this legislation to give you the ability to know how you can avoid or lessen the possibility of a complaint. That's what I think this change does, is give you the tool and the knowledge of how you can lessen complaints lodged against you. You'll never eliminate the possibility that someone will do it, but I'd also like to say that I think we have fundamental questions, because I agree with you. We're starting to go with tentacles here in all different directions. I think we do need to somewhere say how far from that legislator we need to advise that the legislator that he needs to worry about. So, as I said, there are states that just say this only relates to the legislator himself. There are others that say this goes from the legislator to immediate family. I don't know if we've solved that issue first. If we need to know how far does the legislator, when we're advising him, need to expand his thinking about a conflict. Yep.
Would it be helpful to look at what the law currently states on this, which is on page 25, where household member is defined?
Does the language, granted that some aren't happy with the someone the legislator cares about phrase, but it would seem to me that phrase includes all of the people that are mentioned in the current booklet,
Yes.
and expands it beyond that. That's how I envision it, that we are not shrinking the pool of concern, but we're expanding the pool of concern by saying something, as some have characterized it as vague, because it's too difficult to list every possibility. And household member includes someone the legislator cares about. That's a subset of that, I think.
Well, originally, for many years, it was legislator and spouse. And then this was expanded to the current definition about 15 years or so ago. And it requires that the person live in the same domicile and share common economic interests in the expenses of living in that domicile.
Do we, Mr. Lambert, have concerns, or have we had cases where it's not someone that lives in that household? For example, if someone says, gee, my brother doesn't live in that household, but this guy is voting on a bill that benefits his brother. Is that not an expansion that would be fairly common, I would think? I mean,
I don't recall any complaint about
Okay.
that. There's been about 110 complaints since 1992, when the committee started.
Yep. From my standpoint, that would be, and the ones that I've heard anecdotally in my community, it's, and maybe it happens more when we're talking about selectmen and that level, but there are always situations where someone says, you know, sure, he voted for that. His brother is a timber owner and he's voting for, you know, and I'm getting nods around. So it does, I have heard it. So I'm surprised that there aren't, if you say that there aren't complaints along that nature. Maybe it's just grumbling and people move along and figure there's nothing they can do about it. I don't know.
Well, what you're describing might invoke the prohibited activity section, but it depends on the specifics.
You're right. Everything's, the devil's in the details, right? Yes, sure.
I'd just like to make another point that in New Hampshire, our citizen legislature is 400 people. We don't have lawyers at our disposal. We earn $100 a year, unlike the other states that earn much more money and have lawyers at their disposal. I think looking at other states doesn't necessarily help us. Just thought.
It's possible that's true. Don't know. Representative Turcott, do you have a, you've been strangely silent along this whole way here. Yeah, all right, all right. I don't want to run by anyone that has a comment that, or, yeah, please.
Hello.
I
I'm just.
didn't mean to scare you into
Oh
it.
no,
I
my
wasn't going
water.
to call you out next.
No. I'm just new. Obviously, I'm a
Nah.
freshman here. So what I just wanted to comment that the book, I honestly got this book at orientation. I skimmed it. I didn't read it thoroughly. Now I'm reading it thoroughly. But just what I thought was helpful is in the back starting on page 64, they give examples about what is a conflict, when would you disclose, what are your steps. So perhaps a suggestion could be to add more, whatever is hitting the ethics committee now for violations, perhaps some of those examples could be illustrated as what a proper procedure would be, and kind of give more examples. I just find that examples are really helpful to interpret what these rules are all saying, because the language is heavy, and especially if it's lay people reading, they might just see something and be like, they're violating the law, and get all up in arms. But when you read these examples in the back, it kind of makes a lot more sense to everybody. So I just think maybe expanding that examples of how you interpret these rules would be helpful.
Yeah, I don't disagree at all with that. I've always done better with the what happened in what situation and how does it come close to my situation. And to go along with your agreement that someone may read this and say, "Oh, you're violating my." Read on page 1, under the principles of public service, Roman 4. That is, he was mean to me on Facebook. I'm going to file a complaint. It's crazy. But you can read that way. You can say he treat the public with dignity and respect. He called me a bad name on Facebook, and I'm going to file a complaint and make him miserable. Am I not accurate?
That is what caused the increase in complaints, exactly.
Is the social media or number 4, or both?
The social media, and then people looking at number 4 and filing a complaint.
We could add something that says, except for.
So, Mr. Chair, if I understand you correctly, the problem that has come forward, for the most part, is due to social media type complaints brought to the ethics committee against members? Just so I understand that.
Yes, and I have some material for the hearing on 157 this afternoon, which includes material I gave sent to Representative Hill. So I was going to actually talk to you about what they
Yep.
wanted me to do
Okay.
that. But
So
yes, that, and it's not, I don't think it's, the committee is concerned about their workload. What they're concerned about is members of the public saying, well, this legislator did such and such a thing that clearly falls under number 4. And so I'm filing a complaint. And then the committee says, well, this is just a aspirational provision. And so we can't sustain a complaint on violation of that. And then the members of the public lose respect for the committee and for the legislature. That's what Vice Chairman Sytek stated during
Right,
one of the committee's discussions of this.
right,
if
That-
can I follow up with my line with him?
sure.
Okay. So if that's the problem, if that's the big concern that exists right now, how does House Bill 301 solve that?
It's not the big problem.
It's not the only problem.
Okay,
it
but you
is
just
not-
said that was the chunk of
Well,
the
we're
issues
not-
that
We're not debating here. We're just saying,
it's not a matter of debate. I'm trying
yeah,
to
it is. The tone is, well, you use this phrase. What we're saying is there are a number of complaints that have come forth. That's not the sole reason that there's a spike in complaints is number 4. That's not the case. What he's saying is they have received these complaints, and people are using this as guidelines rather than aspirations. We are pointing out that there is a problem with number 4, but it is by no means the sole problem. It isn't what prompted the chairman from writing the original bill that we had last spring. Does that help you?
No, it
Okay.
does. It doesn't.
I'm sorry.
Because if that's, we're talking about dealing with an increase in complaints. If the overwhelming majority of those increasing complaints have to do with Part 4, this bill before us doesn't address that. That's what I'm trying to.
I don't think House Bill 1368 or 301 were meant to affect that.
Right.
There's more than one problem. This is what I mentioned as one problem, but the other problem is when complaints arise, such as the one against the Senate President a few years ago, or involving a former Democratic member of the House who was employed by a union. That's what it's meant to address.
I'm going to suggest, as long as there's no complaints, a 10-minute biological break till 10:30 or so. Does anybody have a problem with that? Thanks.
I'm going to give you credit for that one. That's the first time I've heard it described that way. So you heard it here first.
We're back. Everybody made it back, right? Yep, yep. Oh, no, Representative Payer. Excellent. Try not to say anything noteworthy, or we have to explain back to her, then we'll be good. So I don't know, here's my plan, and I'm open to suggestions. I would like to hear the input from the Ethics Committee. So somewhere, I'm thinking we do this for, another 20 minutes or so, maybe to 11 o'clock, and then recess the work session to after the Ethics Committee meets next Monday at 3.
Yes.
And then we either take this up, we'll talk about it individually of when we can do this, and see if we're any further along after we get input from them. Does that seem reasonable?
Yeah.
I don't think we can do, I don't think we should take any action of amendments or anything, notwithstanding your amendment. I actually would like to suggest that, Janet, bring your amendment to the Ethics Committee on Monday, just as another piece that they can discuss. If anyone else has further things that they would like to have Ethics Committee amend or look at, that would be all right with you. Make sure I get a copy, and make sure Representative Wall gets a copy that she can bring to the Ethics Committee. But again, that, you're not under any obligation to do that. I'm just saying, if there is something that you want to at least say, what do you think about this? It would save time in the process of trying to get to that point. This is our bill, right? So we're doing our due diligence to try to get as much input as we can from whatever source. But with that, we kind of are at this point of almost breaking down the bill into different areas that we have to decide. So we talked about a couple of them. One of which is, what's the purpose of this? And I think it probably is a little of both that we're talking about. Either is it to guide and as a preemptive book, or is it the rule book that will be judged against should a complaint be filed in the Ethics Committee? I tend to look at it more as the former, that it is, the more we can help the representative make their own decisions, I think that's a good thing. Then we have to start getting into those questions of how far it is from the legislator that we need to worry about or advise the legislator. Then we need to get into what types of issues. One of the things that's very odd in here, and I'm not sure how this is dealt with, but we've only ever talked about one side of the ledger. When you vote to benefit someone, or someone that's close to you, or whatever language you want to use, what happens if you're voting against? Can you then vote? Is it okay to vote if?
Were you gonna hurt somebody?
Yeah, I mean,
Can
if
you give me
you're,
an example?
or if not, is it just a blanket, you should not vote when there is a conflict? Or is it only you shouldn't vote when it's something that is actually benefiting someone, not voting against it? If you've always voted against, I'll pick an issue. Charter schools. Let's say you've always voted against every charter school issue. But now your brother-in-law runs a charter school. Is it only meaning that you shouldn't vote in favor of charter schools, or can you still continue to vote against charter schools? That better explained? That's I don't know the answer to that, but yep.
Uh,
worms open.
Yeah, can of worms.
Well, other states do have the detriment in there, and I don't know that it really. I think the real crux of it is benefit. So if we had to focus on one thing, I would keep it as a direct or indirect benefit. But other states in that thing do have benefit or detriment. So they do add it in some.
So
of the states.
regardless of
It could go either way, benefit or detriment, and really it comes down to the influence and what it has over your vote. So if you hated somebody and you did it just to nudge them, technically in some states that would be they should
conflict.
disclose and recuse what they should.
Yes.
But
We have that already.
already.
If you look at on page 18, if you look at that, first paragraph on the sample form of the Declaration of Intent form.
What page are you on?
Page 18.
Where is it?
Page 18,
Yeah,
first paragraph, third sentence.
beneficial or detrimental. Um, so nothing, am I correct in saying that we're not changing any of the forms with 301, so
So-
that would still remain as for disclosure. What about recusal? Would it be the same?
It could.
Well,
I mean, yes, I would think so.
okay,
But maybe that should be more specifically stated somehow in the wording.
right. Maybe it should just be said benefit, well, as it does here, either beneficial or detrimental. That's all you'd need to say, right? That recusal would be an option. What was the other section that I had thought? Oh, there's another piece in here that is very important, I think, and I think people should think on this. To me, it doesn't matter if anyone else is getting this benefit similarly situated as it is now in this book. To me, if you are getting the benefit or someone you care about is getting the benefit, that's all that matters. It doesn't matter if there's other financial advisors are getting the benefit. They're not voting on it. You are, is the way I look at it. I don't know if that's I don't know if that's a good way to think or not, but that's how I think of it. Yep.
Problem with that is, where do you cut it off? In other words, you own stock in AT&T. I own stock in AT&T. We vote on something that benefits them. I am far, 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 far from a major stockholder in AT&T. Okay? I'm getting no more benefit than anybody else. But if their stock goes up, I'm getting a benefit. Now, do you put it at, you own 2% of the stock of the company? Is it got to be 10% of the stock of the company? You run into a problem because everybody out here, if you own a mutual fund, odds are you own stock in most companies. They're spread out all over the place. Where do you draw the line?
So, yep. Do you want to go? We've thought about this. You've talked. Go ahead.
Me gasping.
Yes.
It brings to mind a situation where AT&T was an issue before us.
Right.
And
That's why we brought
there
it.
was a whole line at the clerk's office to file, and actually we were going overboard. It's if you benefit more than somebody else.
Currently.
Yeah, yeah.
Currently. But none of those, and maybe the way to handle it is the same way we've put in here for the exclusions to recusal, that, it wouldn't apply to the budget because virtually all of us have something in the budget that affects us somehow, and we'd be eliminated from having a quorum if everyone excluded themselves from that. there's also an exclusion in here for general revenue bills or bills of such great interest where a large percentage of the members would be affected as to cause a problem with quorum. So I kind of put it in that category. Maybe there needs to be something different. It's obvious. I can't see that anyone said would come back and file a complaint. Again, if I'm looking at this as an advisory thing for the legislator, I can't see anybody coming back and saying, I'm in danger of having an ethics charge filed against me because I own Vanguard, Capital Growth Fund. I understand your point, but somewhere along the line, you can drag this thing out to,
You can draw it out too far.
right, to lunacy.
This is a guide to each individual and only a guide. Everybody in this room should have an ethics standard that they built up over their lives. Okay? They should. It may not be a good one, but they've got one of some way, shape, or form. This is just a guide to give them, okay, maybe what I'm thinking, this thing says it's not the best idea. Okay, maybe I change, maybe I don't. But you've got an ethics background already. So it's not for everyone else. And if you think it's for everyone else, then you really are a politician. And if you don't want to think of yourself that way, then it's got to be for you only.
I don't think I could have said that any better.
Well, I have a question then, and I think we need to clarify this. The words in this book, is this the standard to which the ethics committee makes a decision whether you violated the rules or not? Is this the standard the ethics? Because if it is, this is not a guide. This is a standard.
Well, it's really both. But anyone can file a complaint against you if they feel that you violated one of the provisions in the booklet. And there are other provisions which are misdemeanors if you violate them.
Which is if
The
if
gift.
you materially, well, if you materially don't list every one of your real or perceived benefits, or if you knowingly leave off something off your
Yes.
statements,
Yes, exactly.
that's where the misdemeanors come in.
And also violations of 14C, which is the gift.
But I think the bigger, to me, the bigger part, rather than the book, I think the bigger part is then that those steps that you mentioned earlier, the initial conversation, I forget the phraseology they used for that,
Initial review.
the initial review. That's a bigger piece of that determination of whether you are in violation or not than this. And then the next step, when you're actually brought in, if you pass that or don't pass that initial review, that's a bigger step than this. I think we still come down to that. I don't know what the percentage is. To me, this is 80% guideline, 20%, whatever it is you want to call it, the sentencing guidelines. I mean, this is, yeah, that's a bad phrase, isn't it? This is more aspirational and more, but beyond just the guideline, it's also to me, the ability to advise the legislator how to mitigate or lessen that chance of you can't eliminate, but the chance of a complaint being filed against you. That was what 301 is about. Yep.
Question. The Ethics Committee. Anything you decide in the Ethics Committee, is that final other than removal, thrown out of the House, which has to go to the full body? Or does anything you come up with have to go to the full body?
Any sanction that's recommended is a recommendation by the committee to the body. Now, there can be informal resolutions where the respondent agrees to that he or she did something incorrect, and they'll take certain steps to make sure that doesn't happen again. And that is what we had in the 2 complaints I mentioned.
And that was internal to the committee. That
Yes.
never went to the floor.
No, it was published in the calendars, though.
Yes.
It was public.
Okay, so you act as quasi-judge, which means you follow this, but like any judge, your ethics background might say, well, something in here might not be exactly right, and and if others agree with you on the committee, that could be put aside. Yes, no, or are you bound and you have to
Well,
adhere to every single, thing that's in there?
the committee will decide if a complaint has merit or not. And at the end of the certain process, at certain points, they make a recommendation to the body. Reprimand, censure, or expulsion.
But the devil is in the details, right? I mean,
Right,
it's impossible for them
To put
to
all the
write
details
this,
in.
yeah, and put all of the relationships and all of the other things that could be affected. Somewhere along the line, it does become,
Quasi-judges
yeah, you
decision and how they interpret it.
and interpret your circumstance and your explanation of the circumstance.
If you wish to see those complaints which were public are on the committee's website. And you can see those which have gone to a formal hearing have resulted in a special report, which are pretty lengthy and are pretty much like a court decision. And you can see how they go through each of the charges and what they find, what their findings on each.
My concern has always been, and you spoke to it earlier, that all of us come with our own level of ethics, but somewhere there needs to be a recognition that because we are a legislature, your ethics and your ethics and your ethics affect my ethics or my reputation or my anything. And that's also part of this. We aren't operating in a vacuum, and so we get tarred with that great big brush along the way.
That's what you have to be careful of.
Well, among everything, yeah. Yep.
So if we're treating this as a guide for the ethics committee, can we get a copy of the actual rules that they use to make their decisions if this pink purple book is not that set of
Well,
rules?
the committee's rules are in the booklet.
Oh.
The committee's procedural rules are in the booklet.
Okay, so they are then judging a member's complaint based on what is in this book.
Yeah, beginning on page 40.
I've never known why more people don't ask for an opinion prior to full disclosure. One of mine, is it mine printed in here?
No, it's on the
Oh.
website, though.
Mine is on the website. It gets into that, what's the phraseology? The better to ask permission than forgiveness, or vice versa. I always thought, especially with this kind of thing, that you're better off discussing it before it becomes an issue. But,
I wasn't aware that the ethics committee would do that.
oh, sure.
So you can go to the ethics committee and say, I have a particular scenario that I'm concerned about, and they will make a preliminary decision based on the circumstances you present before them?
Yes, look on page 27. I keep telling you to go to different pages, but page 27 RSA 14B3, paragraph C, talks about one of the committee's duties is to render advisory opinions.
And those get published in the calendar, Steve.
What their opinion on a question gets published in the calendar?
It's public.
Yep. So I'm guessing, but I'm fairly certain that you've been here and got a calendar that had one of those listed on the front page. Yeah.
And the committee can issue interpretive rulings on its own motion also. If it hears there's confusion and or something that needs to be clarified, which is what those two items are at the back of the booklet. Those are interpretive rulings.
See why it's 68 pages long? It's in here. It's just, I don't know many people that are legislators and have been legislators for years that are confident they know this book. And that has always, well, you've been here how many terms now? Right. It is always, if you ask anyone when they filled out the forms every year or every 2 years or whatever we're doing now, are you confident that, well, I filled it out the best way I know how. But no one has a level of confidence that they are doing everything the way that they're supposed to be doing it. And that's not right to me. To me, that's where this guideline, that's where this book needs to be simpler with less definitions and more, again, aspirational. Here's how we should be operating individually, because we do affect all of us collectively. That's how I look at it.
It's a moving target, and it's going to stay a moving target. It's not going to change. Okay. When my father, your father, whatever.
Microphone?
Oh.
Thanks.
When my father, your father, whatever, were in the military way, way back, you could tell a dirty joke. You can't now. Okay? Somebody might be offended. Okay? Somebody might be offended by something you tweet or put out on Facebook.
That's in Roman 4.
Yep. But you can't do that anymore. Somebody might be offended later on because you wear a tweed jacket. Okay? That might offend somebody. That may come out later on that, okay, that's grounds for this. It's a moving target that always changes based on societal norms.
Evolves.
Yep.
I think when this bill first came to us, the point of the bill was for whether or not we should decide, should we recuse ourselves for somebody that is outside the family member, outside of your spouse or somebody that you care about. That was the original language, and we have an amendment with some different language. That's what I think we need to be focused on here. Do we agree or not agree that we should take that step further to go beyond the household? Is that if is somebody outside of your family has influence over you? Is that something that we should put in the ethical guidelines to say you should disclose or recuse your vote? I think that's what we need to figure out here, right? I mean, that's what the bill is. It's a recusal or a disclosure of somebody outside of our family. And are we okay with it? Is that what, and if that is the case, if the general feeling is that that's something that we should do, then we can dial in on the language on that. Yeah, it's a moving target. It's all of that. There's a whole book. We can be here for like 3 years going over this, but do we want to take that step beyond the family? Are we comfortable doing that? And then it just becomes a matter of, it's our bill, right? It becomes a matter of how we define it. We can define it any way we want to. It's our bill now, right? So
Mhm.
we can amend it to, but it's that first step is, are we going to go there? It's, and you know, I mean, personally, I'm comfortable taking that leap. I think it is an ethical violation of my best friend if he or she has a material interest and I'm influenced by that decision. I feel personally like that should be a guideline in this book to say you at minimum have to disclose and make it easier to recuse your vote on that one. And because sometimes it's not easy to recuse yourself, especially if votes are close, right? But we need to make it clear that no, this is something that we probably should step back from on this vote. And that's the step we need to figure out if we're willing to go there.
I have a question.
Sure.
As someone who takes the Constitution very seriously, if a vote that someone perceives might influence or might be influenced by a best friend or someone in my family violates the Constitution or my constitutional oath, where does that leave me? Do you see what I'm talking about?
No, I don't.
What if I use the Constitution as my litmus test whether or not to vote on a bill? If someone fills out a complaint that they think I violated my ethics because of that vote, where does that leave me? Does that ever happen? You can't have two litmus tests. Do you know what I mean?
Yes, well, the committee has always refrained from interpreting the Constitution. That's for the courts to do.
So they would dismiss. Is that
Probably, unless there was some other, if they found there was some statutory or other provision that was violated.
I think I've read, at least for the time that I've been here since 2010, I think I've read all of the possible ones and I haven't seen anything like that.
That violates.
Yeah, I haven't seen anyone say, I voted this way because of the Constitution. I don't know that I've ever even read the word Constitution in any of the complaints that come there. So if that helps you, I don't know.
Not really.
Bless you.
I'm sorry.
Um,
Moving on.
I getting back to Rep. Constable's suggestion, I think you're right. I think that is a key question. How far from that legislator do we go? Do we go past this idea of household member and the definition that includes financial interest, similar financial interest within the family? I don't know how far beyond that. And that is one of the fundamentals, but there's about 4 fundamental questions that we have to ask.
Just a couple of words, someone with whom you're closely associated.
Might be the winning phrase. I don't know. But again, we still have to answer his question, which is how far beyond the family do we go?
It's entirely possible that you're very, very close to someone beyond your immediate family. I mean, it happens all the time.
Right.
And so it's entirely possible you're involved with someone who's a financial advisor or something. You need to make that call.
Comments? We went past my 11 o'clock semi-deadline, but are we at a good place to stop and wander off and think about and read maybe more carefully the 68 pages we have? And then what does everyone think about the idea that we come back after ethics meets and talks and maybe has suggestions for us? There may be, in addition to Representative Nutting Wong's amendment, there may be others from them, but there may be some from us as well. So all I'm asking is that I be made aware, and also probably Representative Wall be aware if anyone's working on an amendment, And, you know, if nothing else, we can act as a coordinator. If there's two people that are acting on the same kind of an amendment, would be happy to link you two up and so that there's something similar. But, I don't know how you feel. I feel like we're at least having the conversation, and that's a good thing. We will become somewhat of a resource to our fellow legislators in this fashion, because I would almost guarantee you that we know more about this issue after these 3 hours or 2 hours, than anyone else sitting in Reps Hall on February 14th. Well, just because Rich is there, we're gonna all know more, but that's a whole nother story. So it is an important topic. It's probably one of the most important topics that this committee has taken up in the last 3 or 4 terms. Yeah. So I appreciate your attention and your comments, and I'm happy to discuss it with any of you anytime offline. With that, I'll close the work session on 301. And our hearings start at 1? Take a nice long lunch, I guess. If there's anything anyone needs, I'm going to be hanging around here for a little while. But we should be in. We have 3 bills on before. 3. And I don't know about you, but I'm looking forward to all 3 of them. And then we'll hopefully we'll be done with all of our bills, with the exception of work session. And I haven't scheduled purposely an exec session. We have until March 15th to get all of our bills out. I think if everyone agrees, I think we can probably get all of our bills done with 1 day, 1 vote, 1 day. Seems fair, right? 7. And we obviously, we always have the choice if we want to retain something, but I'd prefer not to. That's all I know at this point. So I haven't scheduled anything. You haven't missed anything. If you're thinking that when are we going to do this, and everyone else is execing and we aren't, don't worry. We're under control. All right. Thanks very much. See you at 1. If,
ears, yes, he said you can.
if I can interrupt for a minute, there's going to be a quick 5 or 10-minute caucus by the Republicans and the Democrats. Republicans will stay here. Democrats will use the office. Thank you. So the time being 4 minutes past 1, I'll open the hearing on House Bill 134 and welcome not the prime sponsor, but someone speaking to it, right? Representative Mike Edgar has asked for 2 minutes. Welcome to Legislative Administration.
Thank you. As you said, my name is Mike Edgar. I represent Hampton. And I start out by thank you, Mr. Chairman, and the committee members, for allowing me to introduce HB 134 to you today. The bill establishes the legislature as a public employer under the Public Employee Labor Relations Act and establishes procedures for collective bargaining by nonpartisan employees. The legislature would join the judicial branch and other state agencies which already have or place a program as public employees under the Public Employee Relations Act. This arrangement has been worked well in other government entities. Employers are given a choice as to whether or not to form a union. Existing job action and strike laws would apply. Instead of me going through the history here I have written for you, I'll just basically say that there's been a lot of activity on this, from 1998 to 2022. The interesting part is that one year it passed in the Senate and not in the House, another year it passed in the House, not in the Senate. But nonpartisan employee means an employee whose purpose is to serve the institution of a general court rather than to shape and implement policies that reflect the positions of elected officials. Nonpartisan employees shall include employees in the following offices: the General Court Administrative Office, Legislative Budget Analyst, Assistant, Legislative Services, Legislative Operations, Health Services, General Court Technology Services, Visitor Center, Protective Services, Chief Operating Officer, the Speaker's Office, House Clerk's Office, House Sergeant at Arms Office, House Committee Services, Senate President's Office, Senate Clerk's Office, Senate Research Office, Senate Committee Services, Senate Administrative Assistants, Senate Legislative Aides, and Senate Legislative Assistants. Quite a few people, by the sound. Please consider giving these nonpartisan employees a chance to choose and vote OTP. And thanks for letting me speak, and we might have some questions.
You'll take questions.
Please.
Are there any questions for Representative Egger? I have one. Representative Conley.
Thank you, Mr. Chairman. Thank you for being here as well, and thanks for taking my question. I'm guessing, I just need clarification on this, that this is obviously different with public employees than, say, for example, private employees. They specifically need our permission in order to join a union, whereas in private practice, they have the right to form a union. Is that correct?
That's my understanding, yes.
Okay, thank you. No further questions. Thank you for answering my
Thank you.
question.
Thank you. Any further questions? I have one. Do you know from the list that are here how many employees we're talking about?
I'm told that you're going to hear that in a minute
Okay.
from somebody that knows more than I do.
Well, that covers both of us. Thank you very much for your help then. I don't see any further questions. We're good. Thank you, Representative.
Thank you for the opportunity to speak to you today.
Chair has only one other pink card, and that's from our very fine House Clerk. Honorable Paul Smith.
Setting me up for failure, Mr. Chairman. Good afternoon, Paul Smith, Clerk of the House. Again, as those of you who have heard me talk before, I'm testifying neither in favor nor opposed to the legislation, just presenting you some informational points. Wanted to just go over briefly some of the numbers. Mr. Chairman, you asked a question about total staff for the general court. There are over 100 general court staffers total, and that does include both the House, the Senate, and joint. However, I do want to bring up a couple of points specific to the House, because this is obviously where we are at this point. There are 24 full-time House employees. Pursuant to this bill, 6 of those are politically exempt, meaning 3 work in the Republican office, 3 work in the Democratic office. According to past labor practices, supervisors are usually exempt from these types of bargaining units as well. And that would affect at least an additional 6, the chief of staff and the deputy chief of staff, the clerk and the assistant clerk, the director of committee services and the deputy director of committee services. So that brings us down to 12 House employees that this legislation would potentially impact. I think it's important to know that I'm in my 18th year on staff here in the General Court. Staff has never been surveyed on this issue. Staff has never been approached. Those that are within these bounds, so to speak, have never been asked if we desire to be a member of any collective bargaining unit. I would also note that the unique nature of the legislature is that the Speaker does rely on institutional knowledge from most people here. Most people in the legislature, in terms of the staff, spend their careers here. Most of them start when they're in their 20s and will often leave when they're in their 60s. So the turnover rate here in the legislature is not high. That being said, this is a political institution. This is unlike an executive branch or judicial branch, because the judicial branch, obviously the persons that run the judicial branch are all there for a very long time as well on their own rights in terms of the leadership, because they are appointed until they're 70 years old. The nature of the executive branch is, even though the chief executive does change over every 2 years, the ship of state government does not stop every 2 years, regardless of who the captain of that ship is. And so the nature of government is that government continues. The legislative branch, we change over every 2 years. In this body alone, we typically have about a third that changes over every 2 years. This year, we were a bit above that. We were close to 160 new and returning members, and that has definitely affected perhaps the makeup of the chamber. And having the Speaker have the ability to have those persons that the Speaker historically relies on, usually the nonpartisan staff, stay in their positions is inherent in the trust in the system. That being said, there are times when we do get actors in this branch of government that do advance beyond their political, so to speak, involvement, and the Speaker has historically, and in the mind of many, should have that ability to surround him or herself with the people that are here to advance the institution. And I would just note that in Massachusetts, our very labor-friendly state to the south, this past year, an attempt was made in the Massachusetts Senate to unionize, and the Senate leadership, the Senate President, and the chair of the Ways and Means Committee basically said, given the unique nature of their legislature, that it did not make sense for them at that time. And again, I go back to those 12 people in the House that could potentially organize. I'm aware of at least 4 state employee unions that represent all of the state employees across different bodies, and you could potentially have 12 people represented by 4 different collective bargaining units, which might make things a little bit difficult for our House Legislative Facility Subcommittee. So,
Thank you, Mr.
any
Clerk.
questions, happy to answer.
Are there any questions for, yes, Representative McCarter? Thank you.
Thank you, Mr. Chair. Has there been any research done with regards to the fiscal impacts of getting into this kind of an arrangement?
But there is a fiscal note on the back here. We have had this. This is not the first time we have seen this bill. Obviously, there would be costs associated in terms of certifying votes, et cetera. So those are costs. Those are not borne out in this fiscal note, but those are known things.
Thank you. Any further questions? Seeing none, thank you very much. I have no other pink cards, unless anyone is hiding one. Is there anyone else in the audience that would like to testify? Seeing none, I'll close the hearing on House Bill 134. And we have 15 minutes before we open our next House Bill 157, which gives us a perfect time for those who haven't met. We have a new committee assistant. And if she's listening through the door, there she is. See? See? This is Jamie. I'm assuming you're fine with us addressing you as Jamie, or? Okay. Welcome to Legislative Administration. This is her first full week, right? But anything that you have for questions, feel free to ask Jamie, and then she'll shrug her shoulders and say, I don't know, go ask the chairman, and or Jennifer. Yeah, that's how to do it. Everyone say hello, Jennifer. Jamie, thank you.
Hello.
Thanks for listening. That's good. We embarrassed her nicely. Thank you, everyone. So 15 minutes, and then we'll open up the next hearing.
Thank you, Mr. Chair. This is one of my bills. This bill was a request of the staff of the Joint Legislative Committee on Legislative Facilities to clarify the statute and align it more with current practice. And that's as much as I know. If you have any questions that can be answered from my knowledge, I'll try. But I've also brought Mr. Lambert, who is the staff member for that committee, who will be able to answer many more than I would.
Thank you for your testimony. You would be willing, if there are minimal questions, you'll consent?
I'll try.
Do we have any questions from the committee? Seeing none.
Wait,
Oh,
Representative.
sorry. Representative Tierney.
Thank you for taking my question. When you say current practices, whose current practices? Or what current practices?
That's one of the reasons that we needed to have a bill, because if you read the statute, it says that the Senate and the House of Representatives shall propose by rule which in this session was not done in the House. I am not sure whether or not it was done in the Senate, but I tend to doubt it. Because it's not clear that the Joint Legislative Facility Committee has the authority to order the House to adopt a specific rule. In fact, I would say offhand, they don't have that authority.
Follow up, Mr. Chairman.
Follow up.
Okay, basically from what I can see on this one, the only real change to it is where it drops prior to the beginning of each biennium, the committee shall determine whether to propose to the Senate and House of Representatives that each body shall propose by rule that all legislators, legislative officers, and legislative staff shall attend in person. That seems to be all that's gone. Now-
Yes, I believe that is the case.
And I know I got an email, I'm going to presume the rest of the folks did here, from an individual with the last name of Anastasia or Anastasia, however they pronounce it, asking to vote against this simply because it takes the teeth out of it, making it mandatory for everyone to attend training in person.
Yes, that's true. I'd like to mention two things that you need to consider.
Okay?
The first is that it says each body shall propose by rule. The House or Senate can take this proposed rule and turn it down. There's nothing in the current statute that says they can't. That's one point. And the other is that, like I said, the committee does not have the authority to tell the whole House what it can or cannot do. That's a widely known legal practice that a committee cannot act for the whole. And so therefore, we don't want to have it in our statute something that the Supreme Court has determined is unconstitutional.
Further questions? I have one, short one. We've also crossed out on here that the policy shall be posted in the booklet. Is that because the ethics committee that produces the booklet is not responsible for any rules that have been, except for those that have been passed by the full House, and this was only passed by the Joint Facilities Committee?
I'm afraid I don't know why it is not in the book.
Okay. Thank you. Any other comments, questions? Seeing none, I think maybe my question would be best for Mr. Lambert. Thank you for your testimony. I have a second pink card for Rich Lambert. Could you help us, please? You indicate that you're neutral, you're not for or against the bill, you're here to provide
Right.
information.
As a staff person, I can't advocate for policy. And right now, actually, I don't have a specific new message from the Ethics Committee because next Monday, they will be discussing this in the recusal bill. But I did discuss this with Chairman Ned Gordon, and he said one thing, that if the committee feels that the Ethics Committee should have jurisdiction over this policy, which begins on page 51 of our booklet, then it should stay in the booklet. But the question is, should the Ethics Committee have jurisdiction over enforcing this policy? So they're looking for clarity.
Thank you, Mr. Lambert. You'll take a question or two if we
Sure.
have them? Are there any questions from the committee? I have one. I notice on that page that you mentioned, at least when I found it before, it's part 5, right?
Yes.
That at one time, it used to say as approved, it actually says on page 57, approved January 5th, 2016 by the Joint Legislative Facilities Committee. Does that mean to us, or should that mean to us, that this was never voted on by the full House? It was adopted only by the Facilities Committee, and therefore it's your belief that, or the belief of the Ethics Committee, that this does not fall within their duties?
I don't think they've reached that conclusion. They would like to know. They want some clarity. And I prepared this handout. So this policy includes both sexual harassment, but it's much broader. It includes other types of harassment and other issues, discrimination and such. And several complaints have been founded on by alleged violation of that. And so the committee has tried to work its way through this, but this is a policy. It's not a rule and it's not a law. And in the handout I provided, it shows that, yes, sexual harassment is established by law, something that the Ethics Committee can take jurisdiction over if someone files a complaint. But then on the next page, we see that the definition of rule is that has been limited. And this isn't even a rise to the level of being a rule. It's a policy from facilities. And there's supporting information here about the legislative history, a little bit, very short, about when that change to the committee's jurisdiction occurred, and the committee report saying that it seeks to clarify the committee's jurisdiction in terms of rules. So page 3. And then I included minutes from a committee's meeting where it discussed all of this with the speaker and Representative Wallner. And so the committee would like to know clearly if this is something that is intended for the committee to have jurisdiction over.
Thank you. Does the committee, how did the committee handle complaints that came to it out of this Part 5?
I'm trying to think of, there was one complaint that went public, and that was a complaint against Representative Spillane. And part of that was they did use language in the policy in coming to their decision. Because there's a broader section 2 of the statute which says, the committee should have jurisdiction over matters which reflect negatively on the legislature. So that's a very broad grant.
So the committee, though, is asking for clarification more than anything else. And does this House Bill 157 provide the clarification that you're looking for?
No.
Does that mean that we would need to amend, I guess I answered my own question. We would need to amend this in order to provide clarity for the Ethics Committee to handle complaints of this nature.
Yes, they can handle sexual harassment complaints. It's one of the two avenues that an alleged victim could take, or they could take the other avenue of the accounting office and the person designated to handle those, the independent human resources professional. Or you can file a complaint with the committee. So that they know about that. That's clear. But these other types of discrimination or use of hate speech and so forth, which are mentioned in the policy, they're not certain that they have. And I think they would like a decision made, or maybe this could be more explicit or specific.
Does the committee, I don't even know if it has an official name, but this specific committee that the speaker, I always call it the Speakers Committee, but I have no idea what its official term is.
Speakers Advisory Group.
Does that enter into this as well? And are they looking also for guidance on how to?
That I don't know about, maybe.
Okay.
I'll
Do
just-
things get referred to them from the Ethics Committee?
They could. I don't think they did that yet. Things have been referred to the Ethics Committee from SAG,
Okay.
but the Ethics Committee hasn't done the opposite, gone the other way.
So we would have to decide as a committee which avenue would be best, or which group would be best to handle those types of complaints.
Yes. I mean,
Does this sound like something, I'm saying to the committee, does this sound like something we need a work session on to, or a subcommittee to deal with? Especially if we are asking the Ethics Committee, and they would, well, I should almost ask Representative Wall, if they're able to provide us the language that would generate the direction of, or the pathway for how these complaints are held, correct?
yes, I can't predict what they will decide next week.
Okay. I think we need to, like we did before, I think we need to wait and see how the Ethics Committee meets and discusses. They will also bring this up in their meeting, this bill.
Yes.
And we can use this as a vehicle to do what it is we want to do. All right, I'm good. Anyone else have further questions, concerns, comments? Seeing none, thank you very much, Mr. Lambert. I have no other pink cards. Is there anyone in the extensive audience that would like to further testify? We're good. Thanks very much. Closing the hearing on House Bill 157. And we have 15 minutes.
So just one thing, where's the
on my microphone. Sorry about that.
Thank you, committee chair and committee members. My name is Representative Santanastasso, representing Ringe, Jaffrey, and Dublin. And I'm here today to introduce House Concurrent Resolution 6. So this bill addresses a pressing issue that affects us all, the right to self-determination. The fundamental principle that all people have the right to govern themselves is one that has been fought for throughout history. Yet despite centuries of warfare, we have made no progress towards this end. We still witness instances where governments use violence and military action against those who seek to govern themselves. It is important to remember that no government is justified in using violence against its own citizens or any other group of people seeking self-governance. The use of such tactics is a clear violation of human rights and an attack on the basic principles of freedom and liberty. It is a stark reminder of the oppressive regimes of the past and serves a warning of what can happen if we do not uphold the values of democracy and self-determination. Initiating violence against those who seek to govern themselves is not only a barbaric act, but also goes against the very essence of what it means to live in a free society. It sends a message of fear and intimidation and undermines the fundamental rights of individuals to choose their own destiny. We must acknowledge that the right to self-determination is not just a political issue, but a moral one as well. It is our duty to stand up for the rights of all people, regardless of their race, religion, or nationality. We must support those who seek to govern themselves and to help create a world where all individuals have the opportunity to live in peace and freedom. All this bill does is affirm that military action against those who choose to self-govern is never appropriate. I implore you to join me in supporting the right to self-determination for all people. Let us work together to create a world where freedom and liberty are guaranteed and where the use of violence and military action is never justified against those in the pursuit of self-governance. And a couple of things about this bill. It's very simple. It just says that government is not justifying the use of military action against those who want to self-govern. There's a lot of misconception of what that actually means. Is just that. And if people do wish to self-govern, I just want to point out that as they noticed in the Declaration of Independence, that they wrote that experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to what they're accustomed. So the reason why I bring that up is because what they're saying is basically people aren't going to want to self-govern. They're not going to want to go against government and start a new one, except in extreme cases. If they'll suffer some evils while they are sufferable, like it says in the Declaration of Independence. So that's my testimony for this, and I will take questions.
Thank you for your testimony. Are there any questions? Seeing none, thank you very much.
Thank you.
House will call Matt Samon D. Chouanier. Apologize for my pronunciation, but welcome to Legislative Administration.
Thank you, sir. Good afternoon, Chairman and members of the committee. My name is Matt Saborn Chouanier. I am from Seabrook, New Hampshire. I am the chairman of the New Hampshire Independence Political Action Committee. We support legislation that yields a proper relationship with the federal government and leads to one day an independent New Hampshire. We are proud to support this House concurrent resolution. Thank you for having me today. I believe this legislation to be very self-explanatory. The bill is actually not about New Hampshire, where 29% of the population supports independence today, 42% supports a vote, or even about other states and territories in America and around the world today exhibiting a desire for autonomy, such as the Texas Nationalist Movement, the Yes California Initiative, the Puerto Rican Nationalist Party, the Divide New York Caucus, or Free Tibet. It's about being committed to our founding principles, this resolution. It's about respecting boundaries, relationships, and human rights. It's about recognizing that when, after some time participating in a social contract with others, it might be preferable for one group to dissolve the relationship it has with another and to explore a new path and identity. Sometimes we fall out of love with a person and remain together because we like the idea of the relationship more than the person itself. Upon recognition of this feeling, a mature, constructive course of action that is respectful of both parties should be taken. In 1995, the world witnessed our neighbor to the north, Quebec, vote to remain in Canada. A decade later, in 2014, the world also witnessed Scotland vote to remain in the United Kingdom. 2 years following, the United Kingdom itself voted to leave the European Union. What these three events have in common is that those votes of self-governance were allowed to happen without duress, with the people of each nation freely expressing their will. Freedom includes the freedom to leave. Only 6% of Americans support using military action against any state in the Union that expresses a desire to secede. I'm asking you all today to support Article 7 of the New Hampshire State Constitution, the article that reinforces state sovereignty, and as well as the sovereignty of all future states and pursuants worldwide. Thank you.
Okay, thank you. You have written testimony, I see. Is
Yeah, I read from my script. It's marked up with notes. Would you like it, sir, or?
you could submit it after this?
Yes, sir.
That
Yes,
would be
sir.
fine.
Okay, cool.
You will take questions if we have any?
Yes.
Yes. Are there any questions? Seeing none, thank you very much for your testimony.
Thank you, sir. Thank you.
The third pink card I have, and the final pink card, is from Representative Jason Gearhart, representing Northfield and Franklin, and you support the bill.
Thank you, Chairman, members of the
Thank you.
committee. My name is Jason Gerhardt, and I was already introduced, Northfield Franklin. I was going to take a little bit of a different tact on this bill. So, to the Constitution for a second, right of revolution. Just briefly, I'll quote. Therefore, whenever the ends of government are perverted and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may and of right ought to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. If the members of this committee vote against this bill, being as simple as it is, there's no confusion of what's going on, I would argue that they are upholding white privilege, which we must stamp out. Because how is it that New Hampshire has the ability to declare their right to live free of absurd government overreach, but we're telling people in the rest of the world, you know what, you can't do that. Either we can and everyone can and be self-determination of their futures, or we're saying that somehow due to geopolitical rationale, you can be free, you can't be free. Today we like a country in Eastern Europe separating, tomorrow we won't. I think this field and across the board says these principles are universal. People have the right to revolt against the government that is not serving them, that is oppressing them. And as Representative Senator Sasso said, people will not make this step lightly. Throughout history, it's been very expensive. But I do feel that we need to let people know that if they were to make that decision, New Hampshire will not support using violence against them. That is the key aspect of this. You can make all the declarations that, you shouldn't separate, fine. But the day you start shooting at people for saying, no, we do not want to be part of this government that does not represent our interests, I think that's an important thing to say. And I strongly support the bill. Would be willing to hear any questions from people as to why they maybe are on the fence. This is kind of important. It's very simple. So if there's opposition, I'd really like to hear what it is. So thank you very much.
Thank you, Representative, for your testimony. Are there any questions for the representative? Do you have written testimony? Seeing none, thank you very much for your help.
Thank you.
No one else in the audience, I'm assuming, would like to testify. I'm sorry?
Did anyone sign in?
It's blank.
Blue sheet is blank. I'm going to close the hearing on HCR 6. That does conclude all of our bills. What would we like to do?
Schedule when we're going to come back to exec?
We can do that. Okay. I heard that there were some committee members that were having difficulty with an earlier hour, a 9. Is that true? No? Yes? Does anyone have problems still with the Monday? No. I'm sorry.
How many more Mondays? It's just that that's my county delegation meetings are all on Mondays through March. Like from now, like just so it's just
And
let
during
them,
the day?
yeah, like starting at 9 a.m.
Okay.
from 9 to noon.
Okay.
Missing a few is okay. I just don't want to miss all of them. Just one more.
It could be just one more.
Okay.
What I'm envisioning, I think, is we have the ethics meeting next week on a Monday. And then we get into the next week is when we are supposed to be shut down for that week, right? Is that right?
The following one.
It's the following one?
Look at my calendar.
So we have a session though on the 14th
Yep.
day.
Mm-hmm.
And so we're possible on the 20th to the 24th.
20th is a holiday. 22nd, 23rd are session.
So we're not going to meet on that week that I can see.
Right. And the following
Then
week
the
is
following
school
week is the school week.
Okay.
So now we're into the 6th, the week of the 6th. And we need to probably meet, I'm going to say, on the 6th
Okay.
and do, that doesn't look right.
It's just bad luck. It's bad luck. Yeah, that would be very, very.
Could it be Friday? Can we do Friday?
So,
No.
so we are supposed to be able to, the closing date would be the 15th.
Well, could we
Right.
meet the 13th? That Monday?
If we have amendments to these, everything would have to be done on that day, on the 13th.
Are we talking March? I'm sorry.
Yeah.
My phone. Okay.
Yeah, we just went through the whole,
I'm sorry.
yeah, I mean, it seems silly that we're here in, the first week in February, pretty much, and
Are
I-
we able, Mr. Chairman, to look at any Fridays and
um,
not only at Mondays?
really the only days I'm trying to stay away from Tuesday and Wednesday because that's when municipal and county and I don't know what the situation is currently with environment and ag. But those are Tuesday and Wednesdays. Municipal has been bleeding over into the Thursdays, and typically Thursdays have been our session days, but that seems to be somewhat evolving too. I mean, if we're going on the 14th. I don't know. I wouldn't have a problem with a Friday. Do we have problems? You have problems with a Friday. Yeah. See?
Wow, that's fun.
Anybody want to be chair?
Well, we're suffering from a little bit of, holidays get thrown on Mondays and
Yep.
shutting off for school vacation week.
Does
That
is the school vacation week an automatic no for everyone? Or anyone?
Not for me.
You're out of the state.
What's next Monday?
Next Monday is when ethics is meeting at 3 in the afternoon.
Oh, okay. They were meeting in the morning.
It sounds like I need of the Tuesday, Wednesday, Thursday. What's the best option for anybody? Or is there a no option for anybody?
No Tuesdays.
I'm sorry?
No Tuesdays for me.
No Tuesdays. So of the Wednesdays and Thursdays, is there any that anyone can't do?
Wednesday the 15th, I can't, my wife will kill me.
We don't want that.
Yeah, it would depend on which one you're attempting to do.
Okay. So I'm looking at, what were the 2 days that after the 14th that this session is going to be?
23rd.
Those are the 2 days that I was thinking. So, you know, how about the 8th and 9th of March?
Good.
No problems?
What day would that be?
That would be Wednesday or Thursday. So here's where I think we have a winner. I'm assuming Vanessa's okay. If it works, maybe I'll try to get ahead of or find out from the other two committees if I can have either or both of those days. And then that will give us opportunity to either clean up something or get the amendments in and discussed, and we could probably exec everything in the afternoon and do the work session in the morning like we did today, and then be done. And then it would give us enough time, if it is the 8th, Wednesday, we could actually get it in the calendar, right? That Wednesday, which is another part for us to have to worry about, not you. But it is, I think that may not be bad. So try to keep the 8th and 9th flexible, and I will promise that I'll, as quickly as possible, get one of those 2 days locked in.
So how do you see it? We're execing when and we're doing a workshop when?
I would say exec in the afternoon and workshop in the morning.
Okay.
And if I try for I could potentially try to lock in both days. And then if we don't get something done, we can get it done the next day. Right. That's the thing. I mean, if we can be done and then we don't have to use the next day. I'll have to think of a clever way to word that. So I'm going to say that we think of the 8th and 9th, which is a month from now, which just seems crazy.
We're not doing anything on the 6th?
Why would we do anything on the 6th?
Because it's a Monday.
What's that?
Because it's a Monday?
Because what, he mentioned it early on. the
Was
6th.
it a Monday? Because it's a Monday. No, I don't think we need it.
I don't remember who's had the problem with it.
Yeah, 6 is tough.
Yeah, okay, that's why. All right, I'm going to say that our magic days are the 8th and 9th, and we'll try to get everything done. Keep that open as much as you can. And if you have to, keep the afternoon available so that, because the afternoon will be when we exec, not the morning. Okay? Good? All right, unless anybody has anything else to deal with, I'm going to lock up for the day. Thank you very much for all your questions and